71 of 2019.
For reasons mentioned in the judgment, we find that this is a fit case for conversion of the conviction of the appellant to Section 304, Part 2 of the Indian Penal Code from Section 302 of the Indian Penal Code. Therefore, the conviction and sentence imposed on the appellant under Section 302 of the Indian Penal Code is hereby set aside, and we convict him under Section 304, Part 2 of the Indian Penal Code and sentence him to undergo rigorous imprisonment for 10 years. The period of detention already undergone by the appellant shall be set off against the sentence imposed on him.
Blood. Judgment the chamber. I beg to mention 3 items which are not in the list, my lord. They may be listed after vacation for orders.
But may I pray for listing of a matter for motion on day after tomorrow, my lord? Some urgency is there. Nice, Lord.
Same, yeah, tomorrow is possible, madam. All right.
Well, I beg to mention item number 41, Lord. Perhaps your lordship may not like to take up this matter, Lord. This is a company appeal, Lord.
Why?
Lord, your lordship as a council had moved that appeal, Lord.
All right, let this matter be listed before any other bench without me. Bracket my name.
Deeply obliged.
Please, your lordship, I beg to mention for listing motion tomorrow. I am.
My lord, as regard item number 11, my lord, can it be taken up after vacation, my lord, for admission hearing?
On the prayer of Mr. You are appearing from which?
Petitioner, your lordship.
Prayer of the petitioner's council. Admission hearing of this matter stands adjourned. List after winter vacation.
Deeply obliged.
Lordship, I would like to mention item number 17 of the today's list, Lordship.
Yes,
This matter may be taken up after vacation, Lordship.
on the request of learned counsel for the petitioner, admission hearing of this matter stands adjourned for 2 weeks. List accordingly.
We're praying for listing of a motion tomorrow, Lordship.
Why tomorrow everybody wants?
That's it, then the Friday, Lordship.
Yes.
May it please your lordship, I beg to mention item number 16 on behalf of A. Khonigar, my lord. My lord, the matter may
On the
come.
request of, up 2 weeks, yes.
Like,
May please, Your Lordship. I beg to mention item number 12 of code number 20, my lord.
Yes.
Code number 20. We have the instruction from our client not to press this matter. 12.
What is the case number?
20.
You are for the petitioner.
Yes.
Ms. P. Bora, learned counsel for the petitioner, submits that she has instructions from her client not to press this writ petition. In view of the above, this writ petition stands disposed of as not pressed. Any interim order?
No. Okay.
Please, lordship. Lordship, prayer for listing a writ petition, lordship. From admission, lordship, immediately after vacation, lordship, in the month of January.
May I please, your lordship, beg to mention for listing a matter, my lord, for withdrawal, my lord.
When do you want?
Day after tomorrow. Bless.
Really, it's for motion item 2.
Yes. Yes, Mr. Dhar.
My lord, I have spoken to the SP, my lord, who is responsible for this. My lord, he has apologized. He was not aware of the order, my lord. He told me that. Yesterday he called me, my lord, and it's in a process now. Already yesterday he has called this petitioner to his office. He has talked to him, And he said, it has to be undone. So it takes some time. So my lord, let this matter may come after vacation, my lord. In the meantime, he has also been informed. He is not telling much.
Mr. Jayavardhan, learned counsel for the writ petitioner, also heard Mr. Ardhar, learned additional senior government advocate Assam, who has obtained instruction as per order dated 15/12/2023 passed by this court and submits that necessary corrective measures is being initiated so as to undo the mistake committed by the SP Karimganj. On such ground, Mr. Dhar prays for posting this matter again after the reopening of the winter vacation. In view of the above, let this writ petition be listed again on 5/1/2024 for motion.
5-1.
5/1.
My lord.
Item 3.
Yes.
Well, in this case, one disciplinary proceeding was conducted against number of Joans. And similar charge was given. And afterwards, similar punishment was given. Against that order, number of Joans came before this honorable court. And this honorable court directed that, yes, one charge has been proved and one partially, another has not been proved. Accordingly, directed the respondents to revisit the quantum of punishment. Accordingly, they have got the benefit. And I also applied for them that as this honorable court has observed that one has been proved, fully proved, and another has not been proved. So my punishment should be revisited. But that has been rejected. As I am similarly situated person and similar, my lord, same charge sheet. So I should be given the, my lord, same benefit.
Lordship will kindly take note that his colleagues had approached this honorable court in 2011. That was allowed. He should get, but perhaps he is a fence sitter, Lordship. After that has been allowed, he has approached the authority in 2022.
If you create a fence, there will be people sitting on it.
But in other,
Acha, find out on 5th, we'll post it for motion.
Lordship.
On 5th for motion.
Lordship.
Find out. See, the point here is,
No,
these
otherwise
are-
I am not opposing.
no,
Lordship.
that's all right. But you must tell your clients also, they must understand one thing. The fundamental issue here is of equality,
Yes.
right? Which is a facet of Article 14. There cannot be any question of delay in Article 14.
Yes.
This you must communicate to your
Lordship,
client.
Lordship, I'll do that.
If it is a legal right, some benefit, some additional increment, is that, then it's the matter is
That is
different.
another thing, Lordship, but here,
Equality principles will not be hit by delay.
I will take it up with the authority.
So can we have it on 5th? In the
Yes,
meantime, you,
Yes.
if they want, they can agree to
Yes.
this,
Yes.
because he is still in service. So what is the delay here? It's not created any parallel right.
Lordship.
So please explain it to them.
Yes.
They should also understand the facets. Otherwise, they'll think court is passing orders and all.
I
Tell
do
them.
appreciate.
And I'm adjourning it only for your clients to appreciate
Yes.
and understand. Heard Mr. A.K. Royal and counsel for the petitioner, who submits that although petitioner was similarly situated as the writ petitioners in WPC
Page
number
46.
4510 of the 2011, wherein a direction was issued to revisit the penalty awarded to them, and such direction has been complied with by scaling down the penalty imposed upon those petitioners. And no such order, the similar prayer of the petitioner has been rejected by the authorities. Mr. RKD Chaudhary, learned DSGI, has submitted that the petitioner was a fence sitter and he has approached the court with delay. The learned DSGI has, however, fairly submitted that since it is a question of equality and equal treatment, since it is a question of equality in the eye of law, he be granted time till 5/1/2024 to seek updated instructions from his client. Prayer allowed, one extra copy of the writ petition be furnished to Mr. Chaudhary. This case for motion again on 5.
Item 4.
You write, pendency of this writ petition shall not be a bar for the authorities to take appropriate corrective measure in this case, if so advised.
In the case, my lord,
Yes.
my lord, in 2000, in earlier occasion, PLC recommended the name of the petitioner. my lord. Then subsequently, it was rejected by SLC. Then subsequently, in terms of the honorable court's order, the SLC has considered my case against grade 4 post, my lord. Lordship, have a look, my lord. This is the honorable court's order at page 19, lordship.
Yes.
And in terms of this honorable court's order, my case has been considered by the SLC. My lord, starts from 23 page, my lord.
Yes.
This is the so and so. There was a proposal for appointment on compensation in respect of Drupajyoti Das so and so, Hailakandi in grade 4 post in compliance of the honorable court's order so and so so and so. The matter was placed before the SLC on 26/6/23 and SLC directed to comply with the honorable High Court's order by seeking vacancies from other departments. As per clause 15 of the OM dated 1/6/15, after availability of vacancy, department shall place the proposal in the SLC for consideration for appointment of Sri Drupajyoti Das in grade 4 post. Vacancies from other departments were short, but till date, no department has furnished vacancies. Minutes of SLC meeting and letter seeking vacancies from department are at Annexure 1 and 2 respectively. As of now, no further proposal for appointment on compensation in compliance with the honorable have been received. Now, lordship will find the minutes. Next page, my lord. 24.
Yes.
These are minutes 26/6/23. And it has been considered, but it has not been recommended as because vacancy is not there, my lord. Considered. Now, lordship will find. Next page, my lord. Page 25, my lord. Page 25, 3rd July. The Joint Director of Veterinary Department issued the letter, my lord, to all the departments. As per clause 15, that vacancies has to be. My lord, I'm just reading the contents, my lord. I am directed to inform that SLC meeting dated 26/6/23 has directed all and veterinary department to look vacancy in grade 4 post for compensation ground appointment of Drupajyoti Das so and so. As per clause 15 of the OM dated so and so 1/6/15. You are therefore requested to kindly provide information regarding available vacancy in grade 4 post for compensation ground appointment of your department, which is required for consideration of the case of the appointment of Drupajyoti Das. Now, lordship will find this is 26. The contempt case was pending, my lord. It was closed. The relevant portion at page 27, my lord. MS Devi, M. Devi, Learned Counsel for the Reservation 2, however, submits that the consideration part of the state level committee has been done. And in this regard, she has produced a copy of the minutes of dated so and so 26/6/23, a copy of the which is also furnished to so and so. Since there is a substantial compliance of the order in question, the contempt petition stands closed. This is the contempt petitions. Now, my lord, in between on page 28, my lord, I submitted an application showing thereof in about 45 numbers of posts, my lord. 28, page 28, my lord. And since director is the authority, my lord, to maintain the roster as well as 5% quota, whatever it is. Since 45 posts are there in Hailakandi, Karimganj, or and the Silchar, my lord. If those posts are available, so I may be accommodated. Otherwise, also when they are seeking for post these vacancies, my lord, Annexure F. Annexure F, they have issued a advertisement, my lord, where 5,000 posts of grade 4 are going to be filled up. Lordship, have a look at page 29, my lord.
These 5,000 posts are only in one department.
My lord.
These are only in one department, veterinary department.
No veterinary department as a whole, my lord. The staff college has invited the secretary of State level recruitment commission for class 4 post, Assam Administrative Staff College, Jaharnagar. My lord, since 5,000 posts are there, then if such letters are written to the different departments to accommodate or to have a vacancy, not one way they are saying 5,000 posts are advertising, and another way.
Yes, what do you have to say in this?
This matter petition any date, I will take the instruction, why as per and page 25, we have
All right,
already written, Lordship.
you do one thing. What is the date of this advertisement?
Date of this advertisement is, Lordship,
That is 31 October 2023, my lord. Last Jana Sanjuk, the date is given, my lord.
All right. So what we'll do is we'll fix it for motion immediately, either the first week or second week beginning.
Lordship,
You give us, you obtain the instruction and tell us. We'll dispose it of in the motion stage.
Lordship.
All right.
Yes.
We'll dispose of the matter in the motion stage. But the problem is your contempt case has been closed.
No, but I've been told that since your case has been considered by SLC, that is why, my lord, that has been closed. And now, as well as
All right, heard Mr. B. Chatril and counsel for the writ petitioner, also heard Ms. M. Kotoki.
Okay, for 2367,
And standing counsel animal husband veterinary department Assam appearing for the respond numbers two.
there are two.
my lord,
Lordship.
that part, my lord, I may be allowed to correct, my lord. I'm extremely sorry.
Standing counsel veterinary department Assam as well as Ms. A. Talukdar Lanet G. Assam appearing for the official respondents. Mr. Chetri submits that in terms of the order dated
That is 23/9/22, my lord.
23/9/2022 passed by the learned single judge in WPC number 5893/2021, directing the SLC to consider the petitioner's application for appointment on compassionate ground. The exercise was carried out, but no appointment order has been issued in favor of the petitioner, allegedly on the ground that vacancies were not available. However, by referring to documents available on record, more particularly the communication dated 13/11/2023 bracket annexure capital E, as well as the advertisement notice dated, what is the date of the advertisement notice?
That is
31/10.
31/10.
2023 bracket annexure capital F bracket close. Mr. Chetri submits that sufficient vacancies were available at the relevant point of time so as to consider the petitioner's application for appointment on compassionate ground. Therefore, his case has been rejected on completely erroneous ground and in contravention of the direction issued by this court. From a perusal of the materials on record, this court finds that there is substance in the argument of Mr. Chetri. However, on the request of Ms. M. Kotoki, Learned SC, AHN Veterinary Department, Assam, this matter is directed, we'll post it on 8th of January, so that you will get 8th of January 2024 for motion, so as to enable her to obtain written instruction and appraise this court. One extra copy each be furnished to Ms. Kotoki and Ms. Talukdar, Learned Standing Counsel for the respective departments, so as to enable them to obtain instruction.
It will be listed for motion.
Item 5.
Your Lordship. Lordship, here I'm challenging the appointment and selection procedure of respondent number 5, my lord, as a Gaon Pradhan of village Ishatkhari under Rangia Revenue Circle, my lord. My lord, here the petitioner belongs to a Gaon Pradhan family, my lord, and her father expired on 26/1/2022. He was also serving as a Gaon Pradhan, my lord. My lord may come to annexure 5, that is in page 26.
But why don't you prefer the appeal?
My lord, we have filed an appeal in that is in annexure 10, my lord. Before we have filed a writ here and with a direction to file an appeal before the appropriate authority, your lordship. And we have filed here before the commissioner of lower division at Panbajar, my lord. But still there is our orders are pending there, my lord. Every hearing procedures have been completed, but till now no disposal has been done from their side, my lord.
Yes, appeals not being disposed of.
Lordship, now the authority has been changed, Lordship, per 1611 order, Lordship. Now it is the Principal Secretary GAD Department, Lordship, and the case.
Yes, but the problem is lot many appeals will now be.
Yes, Lordship, they are taking up, but that it is transferring. So the matters are being transferred to the authority who is now present.
Has this appeal been transferred already?
That instruction I don't have, lordship.
All pleadings are completed, my lord, there. But till now, nothing has been done.
Let them have the instruction. We'll close it on the next date. Because in
Lordship.
any case, only direction can be to expedite the appeal, that's all.
Yes, lordship.
Yes.
So you take down. Third, Miss
ST Buck.
Buck, counsel for the writ petitioner, whereas the amendments made in the writ petition on the request of Mr. S. Dr. Leonard SC, Revenue Department Assam, and Miss M. Bhattacharjee, Leonard additional senior government Assam, appearing for the respondents. This matter is directed to be listed again on the 8th of, no, on the 4th of January 2024. So as to enable the learned departmental counsel to obtain instruction and appraise this court as to whether the appeal preferred by the petitioner assailing the selection and appointment of respondent number 5 has been transferred to the competent authority, and if so, whether any progress has been made therein. One extra copy each of the petition be furnished to Mr. Datta and Ms. Bhattacharjee during the course of the day.
That is 6 and 8 disability matter, my lord.
These are covered
Similar.
in orders. 6 and
8.
6 and 8 disposed of. Appearance to level. Appearance to level. If the appearance. Areas and a days and a similar orders. Disposed of.
Public selection.
My lord, may I allow my lord to allow? Another 2 matter is issue has been noticed. May I mention that 2 matter or listing, my lord?
Mention. Give him this slip. Tomorrow it will be listed.
May I please your lordship? Lordship, the petitioners are the engaged workers by the PDSL, my lordship. The PDSL has taken a resolution in the month of July, my lordship, to provide outsourced workers, promote them as a contractual worker, my lordship. That is in page number 55, my lordship. And thereafter, my lordship, in the notice has been issued by the Badarpur as Chief Executive Officer of Badarpur Circle to verify the documents of these engaged workers, my lordship. In spite of, my lordship, I have.
What is the primary relief you are seeking?
My lordship, at this juncture, I am believed for only for the verification of my documents, my lordship, since I am qualifying both the conditions, my lordship, as per the resolution dated 28/6/2023 by resolution number 93. Only verification, my lordship, at this juncture.
Verification of which document?
Verification of my service, my lordship, since I am qualifying both the resolution taken by the board. I am qualifying both the condition number 1, my lordship. I have been directly engaged by the FPDCL and I have been directly paid by the FPDCL.
No. What is the substantive relief? Verification, sending it, this can't be the relief. What is the substantive relief?
My lordship, my relief is, my lordship, page 23, my lordship.
Oh, that I have seen. You please tell us what is the relief.
To consider the services of the petitioners, my lordship. As the board has taken the resolution.
All right, you consider, but don't pass any order in his favor. He doesn't want any order.
No, my lordship.
Only consider.
No,
And then
no, my lordship. I'm sorry, my lordship.
Why don't you tell what is the relief you are asking?
I work to be promoted as a contractual worker, my lordship. Since board has taken the resolution to promote all 5,443 workers as a contractual workers, I have been also.
All right, you file your affidavit. Yes. Let them, will issue notice. You want to be promoted today or tomorrow?
No, my lordship.
Or day after tomorrow?
No, my lordship.
2nd January? No. Then let us issue notice, let them file affidavit and then we'll pass an order. But you come prepared on what you want. You are not sure of what you want.
My lord. Kindly see this resolution, my lordship, page number.
Mr. Hussain, you consider yourself lucky that I'm not dismissing your writ petition. You have joined 78 persons seeking a relief of individual nature, promotion. If all 78 doesn't get it, then nobody gets it. You agree to that? First, be sure what you are asking for. Huh? This has become a place where you can ask for anything. Maintainability, if they raise that issue, your writ petition is gone. You should file individual petitions. Consideration for promotion means what? They are to be promoted if found eligible. All of them can't file this writ petition. Anyway, I'm issuing notice for now. Mr. D. Hussain, counsel for the petitioners, 28 of them are together.
My lordship, yes, my lord.
Huh? 28 petitioners.
28 petitioner, my lord.
So if one is not promoted, all will not be promoted. That we agree? Is it a common cause of action?
My lord, it's a common cause of action, my lordship. Kindly see the page number 55, my
That's
lordship.
what I'm saying. They will consider but not promote. Promotion cannot be common cause of action.
Exactly, my lordship.
Yes. All right. Dues and there was the amendments made in the writ petition. The petitioners are seeking a direction from this court upon the respondents to consider their cases for promotion as contractual workers to the next higher post. Mr. K.P. Pathak, learned Standing Council APDCL prays for some time to obtain instruction in the matter. NOM 6 weeks. Since Mr. Pathak has appeared and accepted notice on behalf of
All the respondents.
all the respondents, no formal notice is required. to
Except
send-
for respondent number one. Respondent number one stated.
And respondent numbers 2.
2 to 8, your lordship. Respondent number one stated.
Who is for state, means Ambassador, additional senior government advocate action for 1, and Mr. K.P. Pathak,
Naam likhwana hai.
and Standing Council APDCL for 2 to 8, service of notice is complete in this case. Extra copy of the writ petition be furnished to the Learned Departmental Council so as to enable them to obtain instruction. It is made clear that pendency of this writ petition shall not be a bar for the respondents to verify the documents pertaining to the writ petitioners so as to assess if they are otherwise eligible to be considered for granting of relief in this writ petition.
Highly obliged, my lordship. I'm grateful.
Maintainability of the writ petition is kept open and will be gone into on the next day.
Respondent number 4.
Respondent number 4, but he is also for respondent number 4.
They are appearing. No, they are appearing. Government advocate will appear.
He doesn't want you to come in. Ms. Bharaji, you are also for respondent number 4. Why is the council not aware who they are appearing for? You don't look at.
No, respondent number, lordship, state of Assam will be represented. State of Assam will be represented by the government of it. Respondent number 2, 3, 4, 5, everybody else will lordship, I will appear, your lordship.
Then why is he
I know
coming?
you took me by surprise, so I just checked, your lordship.
Sorry.
He's not, I don't think I think for some different matter, your lordship.
Who has sent you?
Arda.
Huh?
Arda.
It's respondent number 4 is the CJM APTCL, your lordship. I'll appear.
R. Datta. R. Datta is
Arda.
Ardhar.
I was taken by surprise, your lordship.
Find out what is happening. 2 to 8. Otherwise, we'll have to have arbitration proceeding here to figure out who is appearing for whom. Pass an award and then pass the order.
May it please, your lordship. Well, here the petitioner applied for a post, my lord, page 31, if your lordship sees, my lord, for the post of Kazi, my lord. Page 31, my lord.
Yes.
Well, accordingly, my lord, page 34, my lord, a letter has been sent to him to appear before the interview board. And accordingly, he appeared in the interview board, my lord. As no result was declared, my lord, he filed an application around the RTI, my lord. Then surprisingly, my lord, lordship will see page 36, the reply, my lord. There are 3 candidates, my lord. My name is not there, my lord. With reference to the subject cited above, I have the honor to submit here with the panel of candidates in order of merit for the post of so and so, my lord.
Yes.
My name doesn't appear, my lord.
So you have not succeeded.
No, no, this is not the, my lord, select list, my lord. Only the panel of candidates, my lord. Only 3 candidates' names are there, my lord. The very next page, my lord, the lordship is page 37, my lord. They've given the marks, my lord, only 3%, my lord. My name doesn't appear, my lord.
Ms. Bhattacharya, tell us on Friday why his name is not there in the panel.
Lordship.
Tell us. I heard Mr. N.J. Dattala, counsel for the petition. I also heard Ms. M. Bhattacharya, learned additional senior government advocate also appearing for the state. The primary grievance of the petitioner is that in terms of the advertisement notice dated 1/1/2022, he had applied for the post of Kazi and has also participated in the selection process. But in the panel of candidates notified by the
District Registrar Morigaon.
communication dated 20/10/2023, name of the petitioner does not figure. Mr. Datta submits that the communication dated 2010-2023 goes to show that the authorities have not even considered the candidature of the petitioner, thus causing serious prejudice to his interest. Taking note of the nature of grievance expressed in this writ petition, this court is of the opinion that the learned government advocate Assam be directed to obtain preliminary instruction. Let this matter be listed for motion again on day after tomorrow, date to debug. One extra copy of the writ petition is furnished to Ms. Bhattacharjee so as to obtain preliminary instruction on the aforesaid grievance expressed by the petitioner's counsel.
I'm obliged.
Obliged, your lordship.
Yes. There could be some confusion. Call it again after some time. Piece of material.
May I please, your lordship, Mr. TJ Mahanta is leading me in this case, lordship. He is on legs in court number 2, lordship. And he
Sure.
passed
What is the matter? We'll pass over. Please tell us what is the matter.
Lordship, the petitioner is aggrieved by awarding of marks for PhD to respondent number 6, lordship. As per the office memorandum, lordship, the PhD should be in concerned subject, lordship.
Where is it? Where is the office memorandum?
Page number 27, lordship. Relevant page and page number 29.
Yes.
Respondent number 6 is PhD degrees in page number 37, lordship. Faculty of PhD of this university in the Faculty of Arts, Foreign
No, in
Languages.
page 29, which is the clause you're referring to?
Clause number 5, lordship. PhD degree in the concerned subject from UGC recognized university.
And concerned subject means?
The post is for assistant professor English,
So PhD has to be in English.
lordship.
And her PhD is in
Foreign languages, lordship. Page 37.
English is not a domestic language. English is a
Lordship,
foreign language.
Department of Foreign Languages and Department of English are two different departments, lordship.
But is English not a foreign language?
She, she has.
Their contention is that although she has although the respondent number 6 has done PhD in English, but she has done her PhD not in English
Not in
department but in foreign language department, my lord. Let notice be issued, my lord. In this case, we will
You are appearing for whom?
higher education department 1 and 2.
Lordship,
Ms. Bhattacharjee, notice has to go in this case.
Can you take a the matter after some time? My senior is coming. He will have.
Is there a prayer for interim?
Yes, yes, that's why, lordship. After some time, he is on legs, lordship.
But we'll issue notice here at this stage.
Item 6.
Paso.
Item 7.
notify होना नहीं कि भल के the council is not present, will call for the second time. You should call for me. We'll call all these motion again at 12. The council who are not there at 12, so that you can attend to other work in the meantime. Hmm.
Instead of getting attend 9.
May it please the Lord.
Yes.
My lord, I appear in 1988, my lord, IA.
Which is the order you want to be vacated?
My lord, that is at Annexure E. The order starts at page 32, my lord. But it relates to appointment of assistant teacher, professor in colleges. The marking system was earlier challenged, put to challenge by the writ petitioners. And this order was, my lord, passed.
One minute, Mr. Bosu. So your client has been selected.
Mine is selected, man, interesting, my lord. Your lordship, the direction reads, any such selection pursuant to the advertisement dated 10 to 23 in the said Romia College, Romia shall not be finalized. Now your lordship will kindly come to page
What is
20.
interesting about it?
My lord, interesting is that, my lord, she had prayed for only in respect of, my lord, the subject of Assamese, my lord, the writ petitioner. Now, my clients, my lord, the applicants, they are all from botany, chemistry, and history, my lord. In any case, they couldn't have blocked it, my lord. That is the
Mr.
case.
Chaudhary, if that is the only clarification, we'll give it subject. This order will remain confined to subject Assamese.
My lord,
The prayer may be seen, my lord, in the writ petition.
may I explain, my lord? The petitioners, my lord, earlier filed a writ petition challenging the marking pattern of the, my lord, state government has issued, which is not, which is contrary to the UGC guidelines. Eventually, my lord, this honorable court in the earlier writ petition has held that the marks obtained by the candidates who appeared in earlier point of time, 5-10 years ahead, they will be prejudiced, and therefore a direction was issued to rationalize the marking system. And my lord, pursuant to that, the rationalization has not been done and advertisements are being issued. My lord, this is, in fact, my lord, the prayer is not confined to only one college. It is to the, my lord, entire college. If your lordship, kindly, my lord, this matter of vacating the interim order has been taken up quite a number of times. Your lordship will kindly see the order dated 11/10/2023, 11th of October. That's a common order in all the, my lord, IAs.
Just 1 minute. How many writ petitions are there?
No, writ petition is one, but
Is it
the stay
presently one,
vacating
my lord?
petitions are 3.
Why is that?
My lord, there are 2 candidates, 3 candidates, my lord,
Okay, 4 candidates, my lord. In this application, 3 candidates, and
I am one of the.
that Assamese, my lord.
This is number 2468.
No, Mr. Chaudhary, what I'm asking is,
My lord.
there are 2 petitioners.
Yes, my lord.
They are also applicant. They've, one
lord,
of
in
petitioner number one is applied for
In
assistance.
respect of my lord, Rongia College only, my lord, the petitioner number 1 is a candidate for the subject of SMEs. But the prayer and the reputation is not confined to my lord only SMEs or the my lord the subject of the petitioner number 2. It's a my lord concerning all the my lord advertisements, because my lord our case is that without going for rationalization of marks, as was directed by this honorable court in the earlier petition, you could not go for any fresh advertisement. That is our case. And then, my lord, if your lordship kindly peruses order dated 11th of October, my lord, they may read it, my lord.
Yes, please.
At that particular point of time, my lord, only Rongia College advertisement was there. That was, my lord, annexed, and the prayer was made in respect of Rongia College. But the main prayer is in respect of the, my lord, entire state of Assam, because we do not know, my lord, in which college, which advertisement of which subject will be, my lord, issued. Now,
That will be like a PIL.
in a sense,
No, I'm asking a pertinent legal question, seeking your response. The petitioners having their own grievance, understandable. Petitioners saying that we want the system to change in Assam, may be possible, but that's a PIL.
My lord, no, that there was an, my lord, office memorandum by which, my lord, the marking system was, my lord, the put in place by the authorities. That was under challenge. That was under challenge, and that, my lord, that particular OM, while, my lord, considering that, this honorable court has decided that, my lord, yes, there may be prejudice to the earlier candidates, therefore you go for rationalization and thereafter go for
No,
a
but
pilot.
only the candidates who are before the court will consider their case. What prejudice has been caused to some other candidates who are not before the court? How can that be subject matter
In
of
that
consideration?
event, my lord, the subjects in respect of which the petitioners are there, and that has to be, my lord, in respect of all the, my lord, colleges of the state of Assam.
No, Mr. Chaudhary, what I'm asking is very short and simple. You may have a case on merit. You may be able to succeed in the writ petition. That's okay. But even if you succeed, you cannot espouse the cause of others by filing a writ. You know that.
My lord,
The
your
rule of
lordship,
locus will come in.
your lordship is right, my lord.
Right. So the question here is what the court is, it's a court of equity. This is a court of equity. Just because two persons for some reason don't agree with certain process, with which they may not be directly connected. All the appointments being stalled, who is suffering? The
No, in
college
fact, my
students
lord,
are suffering.
appointments are not stalled really. After this, my lord, the writ petition was filed, as many as 1,500 persons have already been appointed.
So then why should these
Why should we
be held up?
Then, my lord, perhaps, my lord, without going into this, I was, my lord,
No, that's right. That's right.
employing.
You feel free to make your argument. I'm only flagging an issue.
Yes, true, my lord.
Which if you agree, then we don't need to.
Only thing, my lord, I urge that your lordship will kindly peruse the order dated 11th of October, my lord. Thereafter, your lordship, whatever order your lordship passes,
Yes,
my lord.
yes, please. Yes, please.
Has your lordship got that order?
Yes.
Mr. B.D. Goswami, so and so, our judgment dated 21/6/2022 in WPC 104022 in paragraph 33, there was a requirement of the respondent authorities to embark upon a process of rationalization of the marks, and that in the event it is noticed that there is a noticeable variation in the marks of the candidates who appeared in the qualifying examination at an earlier point of time in comparison with others who had appeared at a later point of time, it is left to the authorities to devise an own method as to how to rationalize the marks and thereafter take into consideration the rationalized marks for the purpose of selection. But what is presented before the court to have been done in compliance with the requirement of paragraph 33, as indicated above, is that the Director of Higher Education had constituted an expert committee to discuss the rationalization in the selection procedure as per the office memorandum dated 24/1/2022, which gives a prima facie indication that the requirement of paragraph 33 was not undertaken at all. There is no requirement as per the judgment for rationalizing the selection process as per the OM dated 24/1/2022, and therefore the view of the expert committee that it is found that the criteria and guidelines are rationalized is of no relevance as to whether paragraph 33 had been complied with or not. Mr. K. Goel, Learned Counsel, prays for adjournment to examine the matter.
No, your
So, my
lordship,
lord,
may for once,
this-
my lord.
Mr.
If I-
Goswami, please
just
take your seat. Please take your seat. We'll
No,
come
just-
back to you.
Yes, ma'am.
What is the hurry?
My lord.
We're going out on vacation. If we have a flight to catch, then we'll finish. Otherwise,
It's all right, brother.
please have some.
Certain things have been skipped, my lord.
All right, you make your submission.
My lord.
Court has no problem in hearing you.
My lord.
now
Let-
Mr. Gogoi may submit something, my lord, I do not know, but perhaps, my lord.
All these points are taken, well taken.
My lord.
I am on a slightly different point. Even if you succeed,
Even then, my lord, they may, no, my lord.
if you can convince the court on that count, otherwise the rules of locus cannot be relaxed in these matters. That's the point here.
My lord, in the event, my lord, I'm
In an
looking
court
at,
of equity,
true, my lord.
how does the court ignore their prayer? That's what I'm asking.
Yes, my lord. I get your lordship. I'm looking at from a different point of view, my lord, from another point, is that, my lord, in the event this honorable court holds that this particular OM cannot hold the field by the marking system of which, my lord, they were selected, maybe, my lord, there may be complication.
There may be, but then it cannot be held.
Then, my lord,
If
perhaps,
it is held, it will be according to me.
perhaps,
I
my
don't,
lord,
all the 1,500 people have to be made parties here.
those who have been
Yes.
appointed. So, my
How
lord,
can this rationalize?
may I suggest, my lord, that
Yes.
your lordship may modify the interim order, allowing them to be, my lord, appointed, subject to the final result of the case.
No, of course that will be subject to.
My lord, I'll
Of course
not
it
take
will.
your lordship's time again.
Otherwise, what option is there here? And whether a particular marking pattern needs to be rationalized or not may have relevance if it causes prejudice to your client. But then how can the entire process be held up for that?
My lord. Now, my lord, I have placed my case, your lordship will pass the order.
So Mr. Goswami's client is not in SMS department.
No.
So SMS department we will not clear.
One thing, if I may.
Yes. You are also taking the case for everybody else.
No, my lord. The writ petitioner, my lord. My lord, writ.
Already pointed out that in the other subject procedure, it pointed out that only Assamese subject was here to deal with. So, it is commission of the mind.
That is possible.
Because Wasi has already indicated that was.
No. This is not indication. These are all propositions made to generate an argument. Mind will be made up after the
Yes.
arguments are concluded.
No, my lord, only one issue, my lord. The writ petitioner is very vehemently trying to place his case in a, as if in a public interest.
Mr. Goswami.
My lord, just one
Why
thing, my
would
lord.
he not do it?
But if I place the documents, my lord, she has already accepted the marking system only after being
Are you
unsuccessful.
arguing on the writ petition or on the IA?
No, my lord, just the facts, my lord. Your lordship.
No, we will not go into facts which are not necessary today.
They have also filed a writ appeal that is also pending.
Mr.
I'm
Goswami,
coming back, my lord.
what is the point in trying to
Yes,
prejudice the court?
My lord, I leave it to your lordship.
Stick to what your
I
assignment
leave it to your
is.
lordship.
You have come up with a plea that they are not from SMS
Yes,
department, so why are they holding my appointment?
Her
That plea
prayer is only confined to Assamese, so we are not in
enough.
Assamese.
In
My lord.
interim matters, you put forth your best argument,
Exactly.
uncuttable argument.
My lord.
You have done it. Now you are going to your third and fourth grade argument, which will put you into trouble. Then we'll go into the
My lord.
merit of the writ petition. This might sound unequal, but your clients are from SMS department. So there we have to go into the merit of the matter. The same principle on which this IA will be held, determined, cannot be applied in your case.
Lordship, actually, the first writ petition which was filed, challenging the marketing system, Lordship.
So that will be on the merit of the matter.
Yes, Lordship. Definitely,
That's what I'm saying.
Lordship, in this case, when this writ petition was filed, Lordship, I have not implemented as a party. I was not, subsequently I filed implemented petition, thereafter we have implemented. and
People
Lordship,
have reached the Mount Everest,
and-
now you are
and-
talking about local hillocks.
Yes, Lordship. So far, the Lordship, they challenge the two periods, Lordship. Their contention is that they were their qualification before 10 or 15 years back, Lordship.
So that is on
And-
the merit of the writ petition. We are
Yes,
not
Lordship.
understanding.
But they have no specific Lordship prayer against the Assamese department also. They are only memorandum, Lordship, 24/1 advertisement, Lordship. So I may be allowed, Lordship. What happened, Lordship?
You may be allowed to what?
To join, Lordship. I am appointed. I am not a selected, Lordship.
Which department?
Assamese department, Lordship. Lordship, kindly for a moment,
What
Lordship.
about Who is the other applicant here? Only two.
All our, my lord, appointment letters have been. issued.
Out. Appointed on the mega appointment, my lordship, we have appointed. Advertisement issued on 10/2/23, interview held on 25/3/23, selection held on 28/3. Thereafter, lordship, in mega appointment, Mela lordship, we have appointed all the courts lordship. Thereafter, lordship, when we went to join in the college lordship, then we came to know about the order lordship. Thereafter, we implemented and we submitted application petition. We are on the same footing out for all courts lordship, out of the same advertisement lordship. And their prayer, so far their prayer in
What
earlier.
is your IA number? What is your IA number?
2468. What? We are on the same footing, out of the same advertisement lordship, we have appointed. We have no knowledge lordship, and so far lordship, merit of that for a moment lordship, their prayer already considered by the expert committee declined their prayer and held that lordship, office memorandum was rationalized. Lordship, at present lordship, I may be allowed to join. Our appointment shall be subject to the outcome of the petition lordship.
My lord, the petitioners approached this honorable court immediately after the advertisement. And the direction of this honorable court was that selection pursuant to the advertisement dated 10/2/2023 in the said Ringa College shall not be finalized without leave of the court. So, my lord, when this order was passed, my lord, the selection was not held. Selection has been held subsequently, and they have been selected. But the question of including them at that stage, my lord, we do not know.
That's fine. That's fine. So, Mr. Chaudhary, what do you stand to gain if the appointment are held back? We can always make it subject to outcome of the.
No, so far as the SMS department is concerned, my lord, that is the my lord, post which out of the my lord, not advertised post.
Correct. If you succeed,
Yes, ma'am.
then that appointment will be set aside.
My lord,
But if you don't succeed,
my lord.
then who is suffering? The students?
No, my lord, the question here is, my lord, the issue is to be determined, my lord. The issue that has been raised in the writ petition has to be determined.
Correct.
And there was a direction from the honorable court. The government has to file an affidavit and the matter has been decided early, my lord.
So that will do.
My lord.
That will do. But these are matters where there is always going to be a supervening consideration of the court. Your clients may or may not succeed.
My lord.
But if they don't succeed, see who is facing the consequence. The
No, at
students
least, my
are-
lord, so far as the Assamese department is concerned, my lord, the petition number 1 is, her subject is Assamese, petition number 2 is chemistry, my lord.
But if they are not appointed, then your clients will teach SMS.
No, my lord.
Then who is going to teach?
No, my lord, the selection process here is, my lord, under challenge.
That's what I'm saying. We'll make it subject to outcome of the writ petition.
My prayer would be, my lord, if that is appointed, my lord, the.
Why? That's what I'm asking. How does your client stand to gain if till disposal of the writ petition, nobody is appointed a pursuant to this
My lord,
process?
question is very simple. My lord, do the rationalization and make the selection. That is the only.
So your clients don't stand to gain in any manner, except for the maybe
No, my
ego
lord,
trip or anything.
after the rationalization, my lord, it may be the petitioner, prisoner who can be selected, may be selected.
Who may be selected?
After rationalization, my lord, petitioner
But,
may
it-
be
but for
selected.
that, if you get the order, their appointments will be set aside. We'll make it clear.
Maybe sure.
We'll make it clear. The only consideration is the interest of the students. If teacher's appointment get delayed, nobody stands to gain or lose anything except for the students.
That, my lord, is one.
No, I'm seeking your guidance as a very senior counsel for the bar. Of course, you have a brief to handle. I appreciate that. But all I'm asking is how do the petitioners stand to gain if the
Here
appointments
is
are
a
held up?
case where the action of the authorities are, my lord, contemptuous. We have not come on contempt, my lord. This is contemptuous. And on.
Your clients don't stand to gain anything if the order is, if
My
the
lord,
appointments are held back.
eventually, my lord, if the rationalization, the direction of this honorable court.
We'll make it clear that if they succeed in the writ petition,
My lord.
these appointments would be liable to be set aside and subject to the direction issued by the court, a fresh exercise would be liable to be carried out.
Because,
In
my
a time
lord,
only.
for the justification of this rationalization, my lord, in the earlier judgment, elaborate discussions have been made, my lord.
All right. Take the, heard Mr. B.D. Goswami, learned counsel appearing for the applicants in IA bracket C number 1988 of 2023 arising out of WPC number 16350 of 2023. Also heard Mr. Your name please?
A.T. Shorkar.
A.T. Sharkar, learned counsel appearing for the applicants in IA C number 2468 of 2023 arising out of WPC number 1635 of 2023. Mr. M.K. Chaudhary, learned senior counsel assisted by Mr.
M. Datta.
M. Datta, and counsel has appeared for the writ petitioners stroke opposite parties. Mr. K. Gogoi, learned standing counsel, Higher Education Department, Assam, as well as anybody else? As well as you write like the Miss A. Gayan, learned CGC. Huh? You write like the Mr. A. Chamua, learned SCUGC, Mr. K. Gogoi, learned standing counsel, Higher Education, Government of Assam, and Miss A. Gayan, learned counsel representing the Rangia College, are also present. Full stop. Both these interlocutory applications have been filed with a prayer to vacate stroke modify the order dated 22/3/2023 passed by the learned single judge in WPC number 1635 of 2023, restraining the respondents from finalizing the selection process initiated pursuant to the selection process for appointment of teachers in Rangia College initiated pursuant to the advertisement notice dated 10/2/2023. First up, the writ petitioners stroke opposite parties have approached this court inter alia challenging the entire selection process by contending that the process of rationalization of the marking system, which was required to be carried out.
My lord, we challenge an OM, my lord.
Challenging the OM dated
24/1/2022.
And then the decision of the expert committee.
Pertaining to allotment of marks during selection process for appointment in the post of assistant professors in any government stroke provincialized stroke PDUAM stroke medical college in Assam, as well as the decision of the
Expert committee, page 90. My lord.
expert committee
Page 90.
dated 24/1/2022. Declining the objection to the effect that proper process of rationalization of marks had not been carried out before undertaking the selection process. Full stop. The writ petitioner number 1 was an applicant for the post of assistant professor in the Assamese department in Rangia College, whereas the writ petitioner number 2,
She was not an applicant there, my lord. She's
but
from
the writ
chemistry.
petitioner number 2
Her
did not
subject-
apply for any of the posts
There was no advertisement for chemistry. my lord.
since there was no vacancy advertised for the chemistry department. Full stop. From the averments made in the applications, it appears that the applicants in both the IS were not only selected for appointment in the Rangia College, but they were also issued the order of appointment. However, due to the interim order dated 22/3/2023 passed in WPC number 1635 of 2023, both the applicants could not join their post. Full stop. Mr. Goswami submits that his client is not an applicant for the Department of Assamese, and therefore, even if the writ petitioners succeed in their attempt to assail the selection process on the grounds stated in the IA, even then, the same cannot have any bearing on the selection and appointment of the applicant in IA number. I reported it. Huh?
1988.
1988, full stop. It was a number to supply, 1988 oblique 2023, full stop. Mr. Sarkar, on the other hand, submits that although his client, that is the applicant in ISC number 2468 of 2023, is a candidate belonging to the Assamese department, is a candidate for the post of assistant professor in the Assamese department in Rangia College. Even then, there is no justifiable ground to prevent her. It's a lady, your client is a lady, her from joining, since a large number of candidates have already been appointed by following the same procedure. Full stop. Mr. Chaudhary, done as senior counsel for the writ petitioner stroke OPs, on the other hand, submits that in the absence of the process of rationalization of allotment of marks, the selection process has been flawed, FLAWED, and if the court accepts the contention of the writ petitioners, then it may lead to setting aside of the appointment orders of both the applicants, besides a large number of candidates. Full stop. As such, Thomas submits Mr. Chaudhary, this is a fit case where the writ petition itself should be heard expeditiously and disposed of on merit. Full stop. Mr. K. Gogoi, Learned Standing Council Education Department, Assam, has submitted what?
See, the expert committee's report procedures is already done.
That as per the expert committee's report, rationalization has already been done,
Yes.
and there is no further scope to entertain the plea raised by the petitioners. Full stop. I have considered the submissions made at the bar and have also gone through the materials available on record. Full stop. The first and foremost consideration for the court in matters of this nature is that whenever appointment of teachers is withheld due to orders passed by the court, it is the students of the educational institute who suffer directly. Full stop. In the present case, the writ petitioners do not stand to gain in any manner if the applicants are prevented from joining their respective post. On the contrary, if the petitioners succeed in the writ petition, appropriate relief can always be granted to them. Full stop. It is also to be noted herein that out of the two writ petitioners, only one petitioner had submitted application pursuant to the advertisement notice dated
10 to 23.
10 to 2023. Therefore, even if she succeeds in the writ petition, she can at best fill up only one vacancy and no further. Full stop. Whether the entire process of selection stood vitiated due to alleged non-rationalization of the marking process is a matter which cannot be entertained in this writ petition, since this is not a public interest litigation. Full stop. In other words, the petitioners can seek relief only to the extent which they may pray for in the facts of the case based on their own locus in the matter and no further. Full stop. Having regard to the facts and circumstances of the case in its entirety, as well as the supervening interest of the students and the college, this court is of the opinion that the present is a fit case where the interim order dated 22/3/2023 is liable to be vacated. Stop. Ordered accordingly. It will now be open for the authorities to permit the two applicants, namely so-and-so and so-and-so, to join in their respective places of posting. Full stop. The appointment of these two applicants would, however, be subject to the final order that may be passed in the writ petition. With the above observations, both the IS stands disposed of. And in the writ petition, you write, heard Mr. M.K. Chaudhary, learned senior counsel appearing for the writ petitioners. Also heard Mr. K. Gogoi, equivalent number the so and so, so and so. On the request of Mr. Chaudhary, this writ petition be posted a date.
My lord, let them file the affidavit, my lord, that is very
All
important.
right.
my lord.
Since Mr. Chaudhary has expressed urgency seeking expeditious disposal of the writ petition, the respondents are granted time till 30th of January 2024 to file affidavit, failing which their right to file pleadings in this writ petition shall stand struck off. This writ petition be listed on 13th of February 2024 as a fixed item. The matter will be taken up for disposal at the stage of admission hearing. Parties to come
My lord,
prepared.
I made a wrong submission, my lord. Petitioner number 2 is physics, my lord, not chemistry.
All right.
All right.
Physics.
How did they- how you do- This was a this was a- how- How less? It is one item, this was a-
The lordship may kindly take up the main contempt petition first, my lord, before I go to the implement.
You want to implement whom?
My lord, implement actually is not my job, but since they have said that
Implement
it
is
is.
never anybody's job.
Yes,
but
my lord.
We have to
Because-
pass orders.
But
yes.
what has happened, my lord? I am now 76. In
Hmm.
2006, I retired. This court in the first batch has directed the Guwahati Municipal Corporation to pay pension to around 500 employees. All of them were paid. Since we did not come before this honorable court, they did not pay us. Then we filed a writ petition before this honorable court. The honorable court directed to pay the pension within 5 months. That order was passed on 1/11/2022. So long it has, thus 5 months had already elapsed, and the exercise that was required to be done in terms of that order has been done. Now they are saying that they don't have the fund. 500 they have already paid. For me, they don't have the fund. I have not come for all the 500 petitioners who was in the second round. I have come for only the gentleman who is now 76 years of age. And he is person who may be say 61 or 62, he can wait. But the person who is 76, my lord, at least this case should be considered since he has come before this honorable court, saying that the order of the court has not been complied with and he is not slipping over his rights. So far the implement is concerned, they said that particular they have written to those department in their affidavit. That's why they have they are not getting funds from the government. But that is their interdepartmental correspondence. My basic grievance is that the court has directed to pay me the pension, pay the pension.
Yes, but before that, there is another hurdle, Mr.
Yes,
Kumar.
ma'am.
This is a contempt case.
Yes.
Have you demanded compliance from the OP before approaching this court?
Yes.
Where is that letter?
Yes, madam. Your lordship will find that covering letter at page 120. They were represented by the
Page?
120 contempt petition.
No,
Because
in the IA, before filing this IA,
no, the order which was which I'm come for violation, that order's compliance that letter is at page 120. In the
120 of the contempt case. Actually, you want to implead whom?
Because they said that they have written to these persons.
You want to implead whom?
The commissioner, this commissioner secretary, finance department, commissioner and secretary, department of housing.
Correct. Where is the letter demanding compliance of the court's order to these two persons?
But these two persons we are not required to do at that stage because earlier also they were not party. Our main concern is with GMC only. GMC from where they bring the fund to pay this gentleman. I'm not concerned with that. That is the interdepartmental. Yes.
You have to demand compliance from them. That is the principle on which contempt.
Then your lordship will take up this matter after vacation. We'll come with that covering letter. We'll also furnish them the copy of this court's order and all because it is their job. But I will do it.
To file a fresh application after demanding compliance, you will be able to.
No, we have already sent them it by registered post and all. We'll give this particulars after vacation. Your lordship take up with this.
This matter stands adjourned and shall now be listed after the winter vacation.
Yes, deeply.
BD and senior counsel.
So in this case, on learned senior counsel is at court number 2. If lordship permits me, I may start.
Where is the question of permitting? You want to argue? Court's permission is not required. What is the matter about?
Regarding the selection and appointment of a differently abled person in the post of supervisor under the Department of Social Welfare.
You are arguing for what? Disposal?
What's it,
No, no. Are you arguing for disposal?
Yes, Lordship. This is a matter of 2016. Lordship,
No, otherwise, why are you arguing if you're not arguing for disposal? Who's for the other side?
D not learned senior G.
You can start now.
No, but if you will not adjourn it if we start. If we start, we'll not adjourn it. You call Mr. Nath. Take up.
Oh, he's praying for after vacation, Lordship.
Then why did you say start?
Lordship, huh?
You call him, let him come.
Okay.
Then we will see.
Item 13.
In this matter, we need 4 weeks time, my lord. Lordship,
Mr.
to
K,
file
what-
their affidavit.
Yes, yes.
File their affidavit, Lordship. Instruction not yet received. I pray for fixed.
Petitioner
any
is
date
present.
subject to
Mr. S. Datta, learned standing counsel, PNRD Department, Assam.
fixed date.
Appearing for respond numbers?
All the private, sorry, Lordship, PNRD department. Response number, 1, 2,
1 to 1 to
4 and 5.
1, 2, 4 and 5.
1, 2, 4 and 5. Madam is for 3 months.
1, 2, 4 and 5. And Miss M. Bhattacharjee, learned government advocate, Assam, appearing. for the-
Response number 3, Lordship.
Respond number 3, pray for and are granted 4 weeks further time to obtain instruction and file affidavit. List this case again after 6 weeks as fixed item. In the meantime, affidavit on behalf of the respondent will be brought on record.
Minus.
Item
level.
14.
May I please, Lordship?
Yes.
Lordship, this petition, Lordship, we are engaged as a casual worker in 1993, 1/4/1993.
Yes.
And Lordship, after working so many years, Lordship, we submit a application to Chief Conservator of Forest, praying for regularize our post, Lordship, as fixed pay worker, Lordship. And Lordship, after that application, Lordship, this Chief Conservator issue a letter to Divisional Forest Officer Dhemaji to submit a report. On this report, Lordship, our name is reflected, but our post was not regularized, Lordship.
Where is the list where your name was there?
The list start from page number 19, Lordship.
Page number 19.
19, and our name was serial number 11 and 19, Lordship. Page number 20 and 21. 11.
Lordship, we have received the instructions Our instruction says that after verification, the person was actually not working as a casual worker. And even though his name is included in one of the serial numbers that have been referred by the petitioner, our instruction says that it was only written as an error, Lordship, and that is disputed.
Lordship, in annexure.
Who has disputed this? Which is the authority?
This instruction has been sent by Lordship PCCF's office.
To file affidavit.
All right.
And then we'll deal with it. But if it turns out to be wrong information, then there will be serious consequences. Let them first file, we'll fix a date.
Yes, Lord.
And after that, no looking back. Your name, please?
C. Dekal, Lordship.
Heard Ms. C. Dekal and counsel appearing for the petitioner. The petitioners have approached this court seeking a writ of mandamus directing the respondents to regularize their services. As per the documents available on record, the petitioners were engaged as casual workers on 1/3/1993. On such basis, full stop, on such basis, they have claimed the right of regularization as casual workers since several other similarly situated casual workers have already been regularized. Mr. I.P. Botakur, learned counsel appearing for the Forest Department, however, submits that on verification of records, it was found that the petitioners were not engaged on 1/3/1993, but on a much later date. In view of the above, the respondent numbers 3 to 7 are directed to bring their stand on record by filing affidavit on or before 22nd of January 2024. First up, list this case for admission hearing again on 7th of February 2024 as a fixed item. If for any reason affidavit is not filed on or before the next date fixed, this court will consider directing personal appearance of the concerned officials so as to clarify the departmental stand in the matter.
Or Lordship, the engagement date is 1/4/1993.
1/4/1993, not 1/3. Yes.
Item 15.
At a line you had, although this writ petition was filed in the year 2022, no affidavit has been filed by the departmental authorities till date. Stop. Be that as it may, on the request of so-and-so, the respondent numbers 3 to 7 are granted time till so-and-so to file affidavit facilitating disposal of the writ petition. It is, however, made clear that if the affidavits are not filed on or before the next date fixed, on or before the date fixed by the court, this court will consider directing personal appearance of the concerned officials so as to clarify the matter. Yes, who's appearing? No CGC also in this case.
Lordship, let it be after.
None appears for the petitioner. Mr. S.S. Roy learned CGC praise for posting this case again after winter vacation so as to enable him to obtain instruction. They are allowed listed accordingly.
All right.
Item 18.
Counterparties.
Why is there some mix-up today because of change?
Otherwise,
It's not been notified.
it was notified, Lordship. It was notified. Even the specific item number is also given in the notification, Lordship.
Well, then we'll have it after vacation.
Lordship, Lordship.
None appears for the petitioner on call. Then you are for?
I am for central government, Lord, CGC.
Lordship,
The petitioner has taken the brief from us, my lord.
Petitioner?
Has taken the brief from us.
When?
My lord, long back, my lord. My lord, Lordship may please to issue a notice to the petitioner, my lord. And our names may be struck off, Lordship. All the advocates for the petitioner.
You make an application to the registry.
Yes, Lordship.
Ms. P. Borwal and counsel for the petitioner submits that the brief has been taken away from her by the petitioner and therefore she is no longer representing the petitioner in this case. Ms. P. Borwal is granted liberty to approach the registry for deleting their names, deleting her name from the cause list. In the meantime, the learned departmental counsel to obtain instruction. List this case again after
Lordship,
6
we have
weeks.
filed affidavit on it. Lordship.
The learned departmental counsel, name is so-and-so, so-and-so, so-and-so are present. List this case again after 6 weeks with office note indicating as to whether any new counsel has entered appearance on behalf of the petitioner in this case or not.
Item 19.
Please, otherwise, Lordship, it's a covered case, but the problem here is that the Hospital Management Society has not been made a party, Lordship. There was a writ petition, Lordship, numbered as Lordship 7711 of 2016. It was dismissed initially. Then, Lordship, they preferred an appeal, Lordship, which was numbered as 206 of.
Does the Hospital Management Society has a role to implement the court's order?
No, Lordship. Lordship, but
What is the relief here?
Lordship, relief is, Lordship, they were directed to place their representation, individual representation, and the Hospital Management Society will consider their representation.
No, we are here for implementation of the order dated.
What is the representation about?
To consider their case, Lordship,
We are before the court.
Why haven't you completed the Hospital Management Committee?
Will implement. If your Lordship direct will implement.
Because
No,
appointments
without
were
that,
made.
how the order will be implement? On the request to learned counsel for the petitioner, this matter stands adjourned for 3 weeks so as to enable the writ petitioners to file appropriate application for implement of the concerned Hospital Management Society. So it's a due Pavanyu, learned Standing Council, Health and Family Welfare Department, Assam is present on behalf of the official.
Highly obliged.
Item 20.
20 of this court.
May I please, your Lordship? Lordship, as per the direction of the court, my lord, the Chief Executive Officer of Kamrup Zilla Parishad is present, my lord, before the court.
Why he was reappointed when the order was for reinstatement?
My lord, what happened, my lord? He's at that time he was not there, my lord. His earlier officer, my lord, inadvertently, my lord. That was a mistake, my lord. Within 3 days, we will rectify that, my lord. That is, my lord.
Yes, you are the
Chief Executive Officer.
I am Chief Executive Officer, Kamrup Zilla Parishad.
Yes. Have you understood the point?
Yes, sir.
What do you have to say?
Sir, it was a language mistake committed by my predecessor. It was not in my knowledge. Now I will rectify it. I apologize before the honorable court, sir.
It was a mistake.
Yes, sir.
All right, you rectify it. How long, how much time will you require? Within how many days will you rectify it?
Yes, sir. Within 2-3 days, I will rectify it.
Your name, please?
Sri Parag Kumar Kakoti.
So you are in the SES?
Yes, sir.
You take down in terms of the order dated. What do you write? Heard Mr. I.S. Saikal and a counsel for the writ petitioner also heard Mr. S. Daktal and a standing counsel PNRD Department Assam appearing for the respond numbers 1, 2, 4 and 5. Who else? Miss Talukdar, A. Talukdar, learned G. Assam is present on behalf of the state. In terms of the order dated 22/11/2023, the Chief Executive Officer of the Kamrup Zilla Parishad, namely Sri Parag Kakoti, SES, is personally present before this court and submits that due to misunderstanding of the language of the court order dated 16/11/2018, his predecessor had passed the order erroneously, reappointing the writ petitioner, although the direction was to reinstate him in service. First of assuring this court that within 3 days, necessary corrective measure would be initiated in this case. Mr. Kakati has tendered apology for the mistake committed by his predecessor. Having heard the officer present in person and in view of the explanation as well as the apology tendered by him, this matter is directed to be listed again as a fixed item on 3rd January 2024, so as to enable the concerned authorities to issue a rectified order in favor of the petitioner. A copy of this order shall be placed before this court on the next date fixed, facilitating disposal of the writ petition. Personal appearance of so and so is hereby dispensed with for the time being. Yes. We want the order on 3rd. Give the copy of the order. Yes. All right. 5 minutes, we'll be back.
Attend to.
May I please it, your lord?
Yes.
Lordship.
Which order has been violated?
Yes, your lordship. Your lordship, Annexa B, lordship, page number.
So what is the violation here?
It's a lordship, that is a specific direction issued by this honorable court.
Yes.
As such, the direction of employment and craftsman training Assam Responder number 3 is directed to do needful for the purpose of giving pensionary benefit of compassionate family pension scheme of the state to the petitioner on the death of her husband Popular Burman in consultation with the commissioner and secretary to the government
Yeah,
of
but
Assam.
there is no time limit.
Yes, lordship.
There is no time frame.
Yes, sir. Time has yet to be framed, but authorities should have to comply with the same, lordship. And
Yes, but the writ petition is pending.
yes, lordship, same hand has been
We'll have
pending.
it together with the writ petition. Further direction will be required here. This is not a case of contempt.
In the lead petition, lordship, they have stated that they have filed an appeal before the division bench and same has yet to be numbered. But until then, unless it has been stated by the division bench or the
That's right.
appellate court,
I heard
lordship.
Mr. So-and-so like counsel for the petitioner. Having regard to the nature of allegation made in this contempt case, this matter is directed to be listed after the vacation along with WPC number 714 of 2022. You wait. There is no contempt as on date. You have rushed. Yes.
Item 3.
By order.
Which order?
22/5/23, page 14, my lord. Operative person 15, my lord. The DP was to be, my lord, disposed, we will close within 3 months, my lord, from the order. So now it's December, my lord. They have not closed the DP.
Mr. Art Chakravarti and counsel for the petitioner will alleging willful and deliberate violation of the order dated 22/5/2023 passed by this court in WBC number 8435 of 2022. This contempt case has been filed. Peruse the statements made in the petition NOM 8 weeks. Petitioner to take steps for service of notice upon the respondent by registered post within a week from today.
Item 5.
That regarding 13 marks that given to that, my lord. The lordship kindly see page 29, my lord.
13 marks is given in what? This is a selection process.
Yes, selection.
Selection for?
Assistant professor of English. And my lord, that doctorate, my lord, for doctorate degree, my lord, 13 mark is awarded as per the government notification, which is, my lord, followed by the authority. Your lordship kindly once, my lord, page 29, my lord. Page 29.
Yes.
Clause 5.
PhD in concerned subject. So I am in English. So I am getting 13, all right. But she is getting, my lord, the respondent, private respondent getting, she is the doctorate in foreign language, my lord. Foreign language is a distinct, my lord, distinct subject, my lord, and English is a distinct subject, my lord. And that the respondent number 7, he appeared in SB Deora College, my lord, and that was 13 mark was not given because he is the post of English. So concerned subject mean English, my lord. So that has to be clarified, my lord, because she was not awarded mark in the SB Deora College, my lord. She filed a case that is also pending, my lord. But here in this college, my lord, that 13 mark was given to her, my lord. So if it is, my lord, but not executed, my lord, then definitely it will be in other posts also, it will be difficult, my lord.
Another case is pending, my lord, that's right. But the thing
So in that case, my lord,
here-
she was not granted, my lord.
Here, my lord, director is yet to take a decision, my lord. Already recommendation has been sent to the director. Director is yet to
Yes,
take
in
a
that stage,
final.
my lord.
So we'll dispose it of asking the director to take note of the
yes
guidelines before taking a
That-
decision.
My lord.
Yes, sir,
If
that
the
can be done.
petitioner remains aggrieved in the matter,
Yes.
she will
My lord.
approach once again. All right, take down. Heard Mr. T.J. Mohantal and senior counsel assisted by Ms. P. Bhattacharya and counsel for the writ petitioner. Also heard Mr.
Yes, that's my lord.
S. Das, Learned Standing Counsel,
Higher education, my
Higher
lord,
Education
and
Department, Assam, appearing for the
respondent 1 and 2, my lord.
respond numbers 1 and 2. The instant writ petition raises a question as regards the manner in which the guidelines for award of mark for PhD in the concerned subject from UGC University is to be awarded while selecting candidates for appointment in the post of assistant professor in the provincialized government colleges in Assam.
Yes.
First up, the writ petitioner herein, as well as the respond number 6, had submitted their candidature for appointment as assistant professor in
English department.
English department,
in the
department
English department
of the LCB college.
of the
Lalit Bharali College.
Lalit Chandra Bharali College, Maligaon. In terms of the advertisement notice dated 12/8, 2023, published by the principal of the college. Full stop. During the allegation of the petitioner is that the PhD of the respondent number 6 is in official language and not in
Foreign language.
in foreign language, within quotes, foreign language, and not in English
English.
language, which is the concerned subject
Concerned.
in the present case. Notwithstanding the same, in utter violation of the guidelines laid down by the
Annex of 5, my lord, 24th January 2022.
guidelines laid down by the notification dated 24/1/2022, issued by the government of Assam in the higher education department. 13 marks have been awarded to the respondent number 6 for her PhD done in foreign language, within quotes, foreign language, which was totally impermissible according to the learned senior counsel appearing for the writ petitioner. Full stop. Responding to the above submissions, Mr. Das submits that although a recommendation has been sent for appointing the petitioner, appointing the respondent number 6 in the post of assistant professor in the English department of the college, yet the director of higher education department, Assam, is yet to take a decision in the matter. First up, the learned departmental council submits that if the court directs, the aforesaid aspect of the matter will be duly examined by the director before taking a decision on granting approval to the representation. First up, the petitioner's counsel has also agreed to such an order passed by this court. In view of the above, without expressing any opinion on the merit of the claim of the petitioner, this writ petition stands disposed of with a direction upon the respondent number
2, my lord.
2, my lord.
respondent number 2 to examine as to whether 13 marks could have been, whether any credit could have been given to the respondent number 6 for PhD in foreign language under the notification dated
24 January.
24/1/2022, before taking a final decision on the question of approval of the recommendation sent by the managing committee of the college. Is it managing?
My lord.
committee? Managing committee of the college in favor of the respondent number 6. Full stop. Whatever be the decision in the matter, the same be communicated to the petitioner in writing.
Then if aggrieved, I can, my
If
lord.
the petitioner continues to remain aggrieved in the matter, it will be
My
open
lord.
for him to approach this court once again by filing fresh writ petition.
My lord, deeply honored.
Actually,
Let us tell dispose of accordingly.
May it please your worship.
Yes, please.
This is a petition, this is the second round of petition, my lord. Here, my lord, the petitioner originally joined as constable, my lord, in 1980. Thereafter, he was less Nayak, then Nayak, less Nayak. Then, my lord, Havildar. What happens, my lord? The petition, there was a small incident, that was the petitioner was not involved. Ultimately, he was put under suspension, and subsequently it was proved that he was not guilty. And he was
Promotion, notional promotion.
Yes, notional promotion.
We'll issue notice today.
Yes, ma'am.
Yes, heard Mr. H.K. Mohanty, counsel for the writ petitioner. There the amendments made in the writ petition. The grievance of the petitioner is that he was wrongfully deprived of the benefit of promotion to the post of platoon commander
And Subedar.
and Subedar
Yes.
while in service. Petitioner has already retired from service.
Yes, retired.
Petitioner has already retired from service, and therefore the prayer is for granting notional promotion. Ms. M.
Found it
Bhattacharjee,
that when the juniors were promoted.
which notional promotion with effect from the date on which his juniors were promoted. Ms. M. Bhattacharjee, learned additional senior government advocate Assam, pays for some time to obtain instruction. NOM 8 weeks. You are appearing for?
If all the respondents.
Since Ms. Bhattacharjee has accepted notice for all the respondents, no formal notice, extra copies.
Item 7.
Obliged.
May I please?
Yes.
The matter regarding recovery of excess payment. In this case, the petitioner initially joined in 84 and he retired from service 131/1/2017. After retirement, the SP Dorong made an statement for overdrawn for the period of September 96 to January 2017. Total amount of rupees 9,62,901. And thereafter the petitioner has been retired and the pension payment order was issued 24/6/2022. However, it was recovering from his monthly pension. So at this stage, Lordship may kindly issue notice.
Where is the order? Where is the improved order?
There is no interim order, the statement at page 26.
Where is the order for recovery?
There is no order of recovery, So there is no, as per that statement, it is mentioned in the pension payment order that recovery would be met. Lordship may kindly turn to page 34, Page 34, pension kept in abeyance, rupees 8,096 cumulative, and total pension 24,290. Initially, it was 8,000.
You can make the recovery after 3 years.
Yes,
apart from other grounds.
as per the Shafiq Masih judgment,
Yes,
when the person is retired. Let me get the instructions at this place notice.
I heard Mr. D.A. counsel for the writ petitioner, peruse the amendments made in the writ petition. The petitioner who was serving as
head
assistant in the establishment of Superintendent of Police Darang Kumar Mangaldoy retired from service on attaining the age of superannuation with effect from 31/1/2017. Full stop. Presently, he is drawing pension. Full stop. Aggrieved by the impugned decision of the authorities to recover an amount of rupees 9,62,901 from the pension of the petitioner on the ground of excess drawal made during the period from September 1996 to January 2017, the instant writ petition has been filed. Mr. Karim submits that after the law laid down by the Honorable Supreme Court in the case of State of Punjab versus Rafiq Masih, and Rafiq Masih reported in, do you have the citation?
2015 for SSC 334.
State of Punjab versus Rafiq
Yes,
Masih. Recovery of excess drawing is not permissible in case of a retired employee such as the petitioner. As such, the impugned decision is bad in the eye of law. Full stop. Mr. C.K.S. Borua, Lanet Government Advocate Assam, appearing for the respondent.
1, 2, and 3.
1, 2, and 3 prays for some time to seek instruction. In view of the above, NOM 8 weeks since Mr. Borua, C.K.S. Borua has accepted notice for respondent numbers 1, 2, 3. Mr.
I'm for 5.
Who's for 4? You are the standing counsel or your senior? Mr. R.K. Talukdar, Ardhar is the principal at standing counsel for CAG. Mr. Ardhar, Lanet Counsel for respondent number 4, and Mr. P. Nayak, and SC Finance for respondent number 5. Service of notice is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned departmental counsel so as to enable them to obtain instruction. Hard on the prayer of interim relief, having regard to the facts and circumstances of the case, as well as the law laid down by the Supreme Court in the case of Rafiq Masih, bracket Supra. It is hereby provided that no recovery shall be made from the pension of the petitioner until further orders.
Obvious. Item number 8 is the same, my lord, and it is, my lord, he was the, my lord, UD in the office of the SP Nagaon, and total recovery is, my lord, from, my lord, April 1991 to April 2018, and he retired on, my lord, 8/3/2021, and my lord, total recovery is 14,11,130.
Who is appearing for the AG?
But here I am appearing for the accountant general.
In the other matter also you are appearing?
Other matter, Mr. Ardhar, he is also the technical.
In this case, Mr. A. Hassan, SC AG. And the other matter, Ardhar, SC AG.
1, 2, 3, Lordship. A Talukdar.
Actually, A Talukdar for 1, 2, 3. P. Nayak for respondent number 5. So we have noted the difference, no? The counsel will differ. In the earlier matter, C.K.S. Borua for 1, 2, 3, Ardhar, and the exhibitor A. Talukdar, A. Hassan, and the dates, UDA, amount, period, it is all in the synopsis.
Yes, the synopsis.
Yes, yes.
Oblige me.
Item 21.
Intern Hitu photo. This code. Yes.
Maybe, normal. So the petitioners are, my lord, are meter readers and bill clerks, my lord, in the APDCL, and on contractual appointment, my lord, contractual basis, and they have been working for last 10 years, my lord. Now, there are some other similarly situated persons, my lord, they approached this court, my lord. At page 40, the order of this honorable court, my lord, will find page 33. Operating part, if my lord comes to page 40.
What is this matter about? 1 minute.
Well, seeking a regularization, my lord.
There is already order from the court.
There was a direction to consider some similarly placed employees for regularization. That has been done, but because of our present financial position, we could not give them the benefit. In the present case, Your Lordship, because there was also a direction to consider them for payment of a minimum scale of pay. A scheme has been formulated by APDCL where the pay of contractual workers has been enhanced. So perhaps that benefit the petitioners will get. That exercise is underway, verification of their.
So we'll close the matter then, asking the authorities to give them the
Yes,
benefit.
their cases may also be verified under this exercise.
All right, take down, heard Mr. P.K. Muni, learned counsel for the writ petitioners, also heard Mr. K.P. Pathak, learned standing counsel, APDCL.
I am for 2, 3, 4, and 5. Sit up.
Appearing for respondent numbers 2 to 5.
For one lordship.
Ms. A. Talukdar, learned government advocate Assam, is present on behalf of the respondent number 1. The writ petitioners hearing are all contractual workers working as meter readers and bill clerks under the APDCL. Full stop. They have continuously, as per the case projected in the writ petition, all the petitioners have worked continuously for more than 10 years. Full stop. They also have the qualification to be regularly appointed as meter readers and bill clerks. Full stop. As such, a prayer has been made in the writ petition to issue a writ of mandamus directing the respondents to regularize the service of the petitioners as meter readers and bill clerks. Full stop. Mr. Munir has also relied upon and referred to the order dated 3/1/2022 passed by this court in WPC number 1241/2020, WPC number 1813 of 2020 and WPC number 1332 of 2020 to submit that similar writ petitions have already been disposed of by this court with a direction upon the respondents to consider the case of those petitioners for regularization. As such, a similar order be passed in the present case as well. Full stop. Responding to the above, Mr. K.P. Pathak, learned SC APDCL, submits that due to financial constraints, submits that although the case of the writ petitioners in the earlier batch of petitions was duly considered by the authorities in terms of the order dated 3/1/2022. Yet, due to financial constraints, their services could not be regularized. However, taking note of the ground realities and the predicament faced by the casual outsourced workers such as the petitioners, the company has issued an office order dated 02/12/2023 enhancing the remuneration of outsourced workers such as the petitioners who are getting direct payment from the APDCL. As such, if an order is passed to that effect, the cases of the writ petitioners herein will also be verified for extending the benefit of the office order dated 02/12/2023. Mr. Munir, learned counsel for the petitioner, has agreed to such an order. In view of the above, this writ petition is hereby disposed of by providing that the APDCL authorities may examine the case of all the 9 petitioners herein individually, and if found to be genuine, the benefit of enhanced pay scale as notified by the office order dated 02/12/2023 be extended to the petitioners as well. The aforesaid exercise be carried out and completed as expeditiously as possible, but not later than
2 months.
60 days from the date of receipt of a certified copy of the order. Writ petition stands closed.
All right, Mr. Item 10. This is the report number 20.
This is a compassionate appointment matter, madam. I have taken his copy itself. 2018, that is of 2005. And my lord, the list they are harping on is not a selection list. It is just a list prepared, my lords, who had applied. And perhaps, my lord, the component of compassion has gone.
2005.
Yes, my lord, 2005.
Why there is so much delay? When
And
was the application filed?
application is of 2000. Doesn't have sign. Here is it, 2014. It's of 2014 if we go by date, receiving date. It's annexure 30, page 30 and annexure B.
Yes, sir.
No, but petitioner must have mentioned.
Yes, my lord, 2000, it's 2000. Petitioner mentions that it was applied in 2006. However, annexure says, going by the annexure minus 2014. That's paragraph 4.
Mm. So if your client had applied in 2006, why has she come in 2018?
Your lordship, as per my instruction, your lordship may very well peruse annexure B and C, your lordship, wherein your lordship, her application was also being forwarded, your lordship, and it was being forwarded by the respondent number 7, your lordship, to the respondent number.
So you were waiting so that they process the application.
Your lordship, the very issue is that, your lordship, from the year 1996 till 2010, during that period of time, your lordship, the vacancy which had arisen, compassionate appointments were to be made against those vacancies for the years 1996 till 2010, your lordship.
But I'm asking a slightly different question.
Yes, your lordship.
If you have submitted your application in 2006, your
Yes.
husband died in 2005.
Yes, your lordship.
Why have you come to the court in 2018? That's the question.
Yes, your lordship. Your lordship may very well peruse annexure F, your lordship, page number
Give
30.
the answer. I'm not asking you where is annexure 8. I'm asking you why have you come so late?
Your lordship, the appointments were made in the year 2018, your lordship. As per annexure F, your lordship, advertisement, your lordship.
This is another case of dismissal in January 2024. Sorry. The prayer of land council for the writ petitioners, let this matter be listed again on 10th of January 2024 as a fixed term.
Okay.
Item 30.
Lordship, in this matter, Mr. B.U. Losko was appearing, he is suffering from fever. What will be taken after?
After vacation,
After vacation.
on the prayer of land council for the petitioner, let this matter be listed again after the reopening of the winter vacation. You are appearing? Mr. Ardhol, Lana Departmental Council is present for the official response.
Item 40.
Ito kihitu ko to. Ito to kimana sa lo.
Wait, please, Lordship. This is a matter of 2018, Lordship. We have actually challenged one advertisement published by the respondent authorities, Lordship. In 2018, Lordship, there is an order of this Honorable Court, Lordship, that is on 9/11/2018, Lordship. Kindly may peruse that order.
Yes. 9/11/2018.
18, Lordship. I just wanted to brush the memory of this.
Yes, please.
Heard so and so, so and so. Also heard so and so for the standing council, AP, and so and so. The grievances raised in this petition is that the responding authorities, while advertising 113 posts for veterinary, block veterinary officer under animal husbandry department, somehow exceeded the permissible limit of 50% reservation, Lordship. Actually, in this particular advertisement, 113 posts were there. Only 16 were reserved for the general category. So there was no mention in the advertisement why they have exceeded. So pleadings have been completed. In the pleading also, they are silent about how they exceeded this. So that is why this is the grievance in the present petition, Lordship.
But appointments have not been made.
Years have passed now, sir, Lordship. Only one post should be vacant. That is given in the last line of that particular order, Lordship. One post may be kept unfilled till the next day.
But your client has participated in the process.
Yes.
What is his position? He's selected.
He is not selected, Lordship.
Then whether it's 50% or 80%, he doesn't get it.
Yes, but there is a wrong that has been committed by the authority.
That we'll see in another case. What will you do? You are not going to get any relief.
That is also another issue, Lordship.
So there is no point flocking a dead horse, is it not?
But Lordship, How can they, being a responsible
That will
department?
see,
Yes,
this
yes.
is not a PIL.
Yes,
You can't get any relief even if you succeed.
yes.
So then what is the point?
But at
The
that point of,
legal issue will keep it open.
yes, yes.
All right. I heard Mr.
PM Taluk.
PM Talukdar, Learned Counsel appearing for the writ petitioner. Also heard Ms. P. Sharma, Learned Counsel, Standing Counsel APSC appearing for the respond numbers. You don't know.
2, 3, 2 and 3, Lordship.
2 and 3, Mr. Ardhar, Learned Additional Senior Government Advocate Assam is present on behalf of respond numbers 1 and 4.
1 minute.
Full stop. The writ petitioner herein has approached this court assailing the advertisement notice dated. Which page is the notice you say?
Lordship, the advertisement is page 18, Lordship.
Page 18.
Page, Lordship.
Relevant page, I think.
And actually, it is dated 17 February 2018, Lordship.
17 to 2018 issued by the APSC for filling up. How many posts?
113, Lordship.
113 vacant posts of
Veterinary officer or block veterinary officer.
veterinary officer oblique block veterinary officer under the Animal Husbandry Department in Assam on the ground that the reservation of posts as projected by the advertisement notice exceeds the maximum limit of 50% and therefore the advertisement is bad in law. Full stop. Taking note of the grievance expressed in the writ petition. Now, you take the petitioner had participated in the selection process as a general category candidate.
Yes.
Therefore, taking note of the grievance of the petitioner, this court had passed interim order dated
9/11/2018, Lordship.
9/11/2018, directing that one post be kept vacant till the next date. Full stop. During the pendency of the writ petition, results of the selection process has been published, but the writ petitioner was not selected. Moreover, the appointments have already been made. As such, no live issue survives for adjudication in this case. Full stop. Insofar as the legal issue is concerned, adjudicating the same in the present writ petition would be a mere academic exercise which would not render any fruit, since the petitioner himself has not been selected in the process. As such, by leaving the legal issue open to be decided in an appropriate proceeding, this writ petition stands closed as infructuous. Interim order dated 9/11/2018 stands vacated. You take the plea in an appropriate place. We'll answer it. Yes. Would not bear any fruit.
May it please your lordship. My lord, the respondent has not filed any affidavit, my lord.
Who is the APDCL counsel here?
My lord,
What is this matter about?
my lord, I appeared in the interview for the bill clerk or meter reading, my lord. And thereafter, my lord, my name has been placed as withheld candidate, my lord. And thereafter, my lord, they have taken a review of the withheld candidate, but my candidate has rejected, my lord, which I found, my lord, on the basis of the impugn letter, lordship may kindly see, page 31, my lord. Those are the withheld
My
candidates.
colleague, Mr. S.P. Sharma is handling this matter. Perhaps he's on legs in another court. I'll just inform him.
There he is.
Yes,
My lord, my senior is on legs. Kindly the matter may be passed.
Who is the senior?
Mr. S.P. Sharma.
Achha, but there is no affidavit filed here. This is a 2018 matter.
yes.
We'll post it after vacation. We'll
My
file
lord, we
affidavit.
file our affidavit after.
Mr. So-and-so and counsel for the petitioner is present. The learned standing counsel APDCL, Mr. S.B. Sharma, raised for another 4 weeks time as last opportunity to file affidavit. Bringing the stand of the department on record prayer allowed, let this matter be listed accordingly.
Highly obliged, my lord.
Yes.
Lord.
What did you?
Adding matter item 12.
Law has directed us to obtain the record, some record we have obtained, and also directed my learned friend to inspect the record. He went to my office and he has seen it.
I have inspected it.
What is the subject matter in this?
Well, the subject matter here is that pursuant to a selection process, the petitioner, she participated. And after the
Selection for what? Which post?
Supervisor regular.
supervisor post in the social welfare department.
Yes.
But our case is that she secured less mark in the written, therefore she was not called for the viva, and she was not selected. The claim of the petitioner is that she is a physically challenged person. So we should have considered for that category, and she was not considered, and that is what the challenge is. We said, Malon, that in the application form, she has not offered her candidature as a physically challenged person. And in fact, in the particular selection process, no post was reserved for that category. And after submission of the application, Malon, she has given an application to the director at page 30 in the writ petition. For application, she has requested that in person to that advertisement, I have submitted my application. I belong to that category, so kindly consider me as a candidate of that category.
How many posts were there?
Well, in the advertisement,
20 posts.
20 posts are there.
20 posts.
20 posts.
So this PWD category reservation is 3%.
Is 3%.
So 3% of 20 would be
0.6.
Hmm.
But in course of the proceedings of this case, we were also directed to file an affidavit whether 0.6 can be rounded off or not. To that effect, we have already filed an affidavit long back that rounded off is not allowed. That is what we have taken this stand. In any case, our case is that she has not offered her candidature as a physically challenged person, and the very certificate, the physically challenged person has a certificate. NHR 1 is a certificate of 6/5/2005, and it is valid up to 3 years. At that point of time, she was not holding a valid certificate.
What is the disability of the petitioner?
40%.
40% orthopedic, page 18 of the writ petition. This certificate is valid up to 3 years. It was issued on 6/5/2005.
Regarding the validity, Lordship, my humble submission is that no board has been formed to renew those certificates. Board is formed to issue the new certificate, but not for renewal till 2023.
No, that is all right. You see, the problem is you agree that on merit, you do not meet the cutoff mark to be called for interview.
That is your Lordship,
No, please,
order dated 1810.
please listen to the query of the court. That will be helpful to you.
Yes.
You have seen the record.
Yes.
Their stand is that, forget the PWD right now. As a general candidate, you do not qualify on the written test. That you accept. That position you accept.
No, not.
Then have you filed affidavit after inspection of record?
That's it. The inspection report is here. I have verified the report, verified the case, the CD, and find these things. So you kindly see this. There are 4 Excel files in CD. These are
What is his observation?
List of registered candidates, list of
No,
rejected.
no, first of all, what is it? Who has prepared this?
What are they?
Lordship, I verified it myself.
My learned friend has verified the record.
In
and
the
he has-
presence of-
He has noted down and accordingly he has prepared this.
In the presence of Amarendra Gogoi, Learned Council of Respondents.
Yes.
No, no, you see, but the problem is if you disagree with the projection made, then you have to file an affidavit bringing what you have seen in the inspection.
Lordship,
Otherwise, how will the court
That's-
adjudicate? This report cannot be a basis of finding.
Lordship.
The
My
court
hum-
cannot.
One thing in my humble submission that there is no any record in the CD regarding the marks obtained by the candidates. There is no any final list, only list of registered candidates who offered their candidates. And then now
Okay, okay, now see, there are two parts to it.
Yes.
Insofar as your physically persons with disability is concerned, that not possible. Because they have not reserved any post, you have not challenged the advertisement, you have neither applied as a candidate belonging to that category. Obviously, you can't apply because there is no post reserved. So just a minute.
Logic.
So that part is over. There is no need to labor on that. I can pass a judgment right now on that. On the merit front, his stand is that your client did not secure the cutoff marks for being called for the viva voce. When the viva voce was held, your client did not approach the court. Your client approached the court only after the final result was select list was published, is it not? Right. But you knew that there will be a written test and a viva voce. So was the result of written test published? That
Yes.
so-and-so candidate has qualified in the written test.
just roll numbers are given. Rule numbers were given. There is no any indication regarding the reservation of in the written test.
So how much mark did petitioner secure?
As per my information, they have given me the information that the petitioner secured 17 marks. 17
In the written test.
in the written.
That is out of
17.
Out,
It is 75 marks.
Out
I
of-
have the question paper.
out of
Out of
75,
75.
17.
According to them.
17.
That is where Honorable Court has asked me to peruse the CD.
Correct, correct. 1 minute. And the persons who have been called for viva voce, what is the minimum?
Cutoff mark for OBC, MOBC category was 32.
Thirty-two.
32. no?
Yes. And she applied as general category.
She applied as, yes, Lord.
The cutoff mark was decided by whom?
But,
Was it decided prior to the selection process or after the written marks were opened?
but, I have to just verify the record, Malad.
No, then you better come prepared with all these
Yes,
facts and figures, and you
I'll-
should also file an affidavit. Otherwise, how these things, but that part you forget it, that you will not get it.
And in
But
fact,
this-
we have also said, Malad, that
Yeah.
for special recruitment drive has been undertaken by the authorities for persons with disability. Their petitioner did not apply.
So that part is okay. There was no post reserve. So she cannot apply.
Yes.
And the advertisement is not under challenge.
Advertisement is not under challenge, only they are relying, one thing I must indicate, Malad. In the advertisement, there is a sentence that reservation for SC, STP or STH, OBC category, so and so, so and so. And as per statutory provisions made by the Assam, government of Assam, including reservation for persons with disability as per existing norms, that will be given. That is what they are harping, that you have said that reservation for the persons with disability you have mentioned, why you have not kept post. We said that there are 20 posts, as per percentage, no post comes. But they are harping on this.
This is Supreme Court judgment. If it is more than 0.5, it has to be down. That is a judgment. That is my one.
All right, so you want the final hearing today or you want to have it after vacation? You just decide.
I will file the affidavit regarding this
You'll file an
findings.
affidavit. Then let him file.
Let him, otherwise I must know no, what he finds.
All right,
on
heard
the record,
Mr.
what he wants
N.M.
to indicate.
Hazarika,
Yes.
learned counsel appearing for the writ petitioner, also heard Mr. D. Nath, learned senior government advocate Assam appearing for the state. It is submitted at the bar that as per the order of this court, the petitioner's counsel has been permitted to inspect the Upper Dila. I'll record your name.
Yes, my lord.
Mr. K.K. Mohanty, learned senior counsel of state by Sun. The petitioner's counsel has inspected the records. However, a prayer has been made. However, the findings of such inspection are not on record. As such, on the request of the petitioner's counsel, this matter is directed to be listed again on, we'll have it on 11 January 2024 as a fixed item, by which time a short affidavit on behalf of the petitioner bringing on record the outcome of the inspection of departmental records be filed. Mr. Nath to also come prepared with the queries of the court pertaining to the failure on the part of the department to reserve vacancies for persons with disability, PWD.
Which records? You should also be prepared with records so that if necessary.
Whatever, yes, my lord, available records, whatever we have, we have already got, my lord. I'll place that one.
A short affidavit will be enough,
Yes.
2 pages. This is what has been seen in the.
Yes. Obliged.
Orders, item 34.
You want to say? Orders. What is this?
Lordship, this is a contempt petition along with the IA. I have been freshly engaged in this matter.
You've been engaged on whose behalf?
Lordship, the contempt now.
There are 2 of them.
Lordship,
Contempt.
the situation is such that initially the contempt petition was filed against the only one contempt now, back in 2018. Now, by way of an IA, after 5 years, the second contemptor has been added. Lordship, I don't know if this technical submission sustains, but after 5 years, whether when the allegation of contempt has been specifically made against a particular person, can a subsequent person be added after 5 years by way of an IA or an amendment in the original contempt petition? Given that section 20 purports.
So you want to file any objection?
Lordship.
All right. Then appears for the petitioner when the matter is called up. Mr.
Y. Kothari.
Y. Kothari, learned counsel, submits that he has been recently engaged to representing opposite party contenders in this case and therefore be granted 3 weeks time to file objection questioning the maintainability of the contempt case.
My senior is outside.
Your name, please?
Huh?
Your name?
J.K. Sharma.
J.K. Sharma for the petitioner. On the prayer of learned counsel for the opposite parties, this matter stands adjourned for 4 weeks. You file your.
Lordship.
He is recently engaged, wants to file objection.
I'm yet to receive the copies in full, Lordship.
In the meantime, copy of the contempt petition be furnished to Mr. So-and-so.
Lordship. Deeply obliged.
Please, Your Honor. Service upon all the respondents have been completed, Lordship. Matter may come for admission.
The petitioner's counsel submits that this matter is ready as regards service and therefore be listed for admission. Mr. S.S. Roy.
I'm appearing for respondent number 4.
Appearing for respondent number 4 and Ms. Talukdar.
1 to 3.
And a counsel for the respondent numbers 1, 2, and 3. You are appearing for respondent number 4 as in private capacity.
Lordship.
So then G. Assam for 1, 2, 3 and respondent number 4, Mr. S.S. Roy are present. There is the office note dated How many respondents?
Altogether 6, Your Lordship.
Where is the note on service on 5 and
Lordship,
6?
Lodgemas order is there, 15/12 of 2023.
15?
12.
Lordship, I am appearing for respondent number 5, Lordship.
That's what, nobody sees the file, when.
Lordship, I have got the
This is the
wrong.
only information that
Lordship,
council
I
give.
got the wrong file.
You are
Name-
appearing for respondent numbers 2,
Names are same.
5, 6. That much also people are not able to give.
They have got wrong file, Lordship.
Pathetic. Acha, 1 to 4, Miss Talukdar. 5, Mr. SSY. Office to verify as to whether service of notice is complete on respondent number 6 and list the matter thereafter in the appropriate call. After winter vacation.
Item 36.
Office to verify whether any counsel is appeared for respondent.
May I please, Your Lordship? Your Lordship, as per order dated 15/12/2023 of the proceedings of the Lavazima Court, Your Lordship. Your Lordship, respondent number 5 has entered appearance by way of filing in Wakalat Nama, Your Lordship. And Your Lordship, respondent number 6, Your Lordship, track consignment has been delivered, Your Lordship. And
Yes,
this-
your for
We are for respondent number 5, Lordship. We need 4 weeks time to file affidavit, Lordship.
and Mr. Borua,
Government has already filed our affidavit.
Yes, Your Lordship.
Mr.
D.S. Decca, Your Lordship.
Yes, Dekal and counsel is present for the petitioner. Mr. CKS Borua and G. Assam has appeared for respondent numbers 1 to 4 and Miss
MSK Bora.
K. Bora and counsel for respondent number 5. As such, service of notice is complete in this case. Registry to therefore. There are only 5 respondents here.
Your Lordship, there are 6 respondents, Your Lordship.
Acha. Office note indicates that service of notice on respondent number 6 is complete. As such, registry to list the matter for admission hearing in usual course.
Much obliged, Your Lordship.
Item 37.
Massive application for restoration of the repetition, because this is for default on 16/10. Para 3 and 4, I have stated the ground. Ground is, I was on next in another court, I could not be present when it was called. I render my apology, the petitioner want to pursue the matter. The order is at page number 16, man.
So number of occasions you are absent.
Part 2 list, it was called up once or twice, at the end of the list.
Who is for the respondents?
The names are
Had
reflected.
Mr. B. Gogol and counsel for the petitioner applicant, none has appeared for the opposite party respondents when the matter is called up. This IA has been filed with a prayer to recall the order dated 16/10/2023, by means of which this writ petition was dismissed for non-prosecution. I have perused the grounds stated in the IA. The opposite parties stroke respondents have not appeared to contest the application. In view of the above and having regard to the explanation furnished by the applicant, this court is of the opinion that a good case has been made out for granting the relief as prayed for in this IA. As such, the order dated so and so is hereby recalled. Consequently, the writ petition being WPC number 2934 of 2012, order dated will be 16/10/2023 is hereby recalled. The writ petition being WPC number 2934 of 2012 stands restored to its original file. Registry to list the writ petition for orders, IA stands disposed of.
Highly obliged, man.
Item 38.
Yes, who is appearing?
For the pro forma respondent only. But the Union of India has filed this review petition, Lordship.
Acha, none appears for the review petitioner when the matter is called up. Miss M. Bhattacharjee, learned senior government, additional senior government advocate Assam, and Mr. S. Datta, learned standing counsel revenue department, Assam, government of Assam are present on behalf of the respondents. However, since the petitioner's counsel is absent today, this matter stands adjourned.
Deeply obliged.
Item 39.
Okay, it does.
Lordship, this matter pertains to the non-payment of gratuity to the petitioner. He had approached the honorable court and by order dated 26/9/22, the authorities were directed to pay the gratuity, but till date they have appeared, made their appearance, but
You are appearing for whom?
My lord, I am appealing for respondent number 2. My lord, this is the first time I am appealing, my lord. We have just recently filed the wakalatnama, my lord. So
this
What
6
about,
months.
my lord, we have
what
to
about
take.
service of notice on respondent number 1?
We also, both of them have appeared.
No, I
on-
am for respondent number 2 only.
And for one also somebody has appeared according to the PIS. Petitioner retired from service in 2017.
What is this contempt notice goes and the officer writes to the registry that I have nothing to do in the matter?
For that, my lord, I am.
Meenakshi.
All right, then we have to give her personal appearance.
Yes, Lord.
Because being a bureaucrat, she doesn't know, seem to know the.
Lordship, respondent number 1, Lordship.
Hmm.
May
Have
I
a
be
look at-
allowed, Lordship? I shall contact and Lordship may post it tomorrow or day after, Lordship.
All right. Sponsor for the petitioner, Mr. S. Day, Learned Counsel, Abhijit Day.
Yes, my lord.
And counsel is present for respondent number 2. Notice has been served upon respondent number 1, but instead of appearing in this case, it appears that the contender opposite party number 1 has addressed a letter dated 5/8/2023 to the register of the High Court, indicating that she has no role to play in the matter. First up, the opposite party number 1 appears to be an officer belonging to the Assam Civil Service. However, it is surprising that the officer does not have any idea or understanding as regards the procedure to be followed upon receipt of a notice in connection with a contempt case. First up. Therefore, this appears to be a fit case where the concerned officer should be directed to appear personally in the matter. However, at this stage, Ms. M. Bhattacharjee, learned additional senior government advocate Assam, who was available in the court and was watching the proceedings, have come forward with a request to give her 2 days time to find out as to the circumstances under which the communication dated so-and-so has been issued. On the request of Ms. Bhattacharjee, this matter is directed to be listed again on Friday, the Friday's date.
Lordship.
A copy of this order be furnished to Ms. M. Bhattacharjee. Opposite party respondent number 1, give the name.
Meenakshi Das.
Srimati Meenakshi Das Nath, bracket ACS, who is serving as Director of Cultural Affairs, Government of Assam. Something is coming, tell her.
Lordship.
We'll tell her how to deal with court
Lordship.
matters. Regardless of what you do, we'll call her to the court.
Lordship, I shall.
But we'll modulate the order depending on what is our response day after
Lordship.
tomorrow.
Deeply obliged.
Yes?
A copy.
Yes, what is this IA?
57 days in filing the restoration petition.
But Ms.
Ms. B. Talukdar.
P. Talukdar, learned counsel for the applicant. This IA has been, condonation of delay in IA is not applicable.
Yes, Lordship, we have told it to the registry, but registry said, no, you should file.
No, it's not, it's over. You can't file a contempt case. It's over. Unless
For
you
the
make
ends
out a
of the
case of
case.
continuing contempt, not permissible. There are Supreme Court judgments.
Actually, your lordship may kindly peruse the order dated annexer, page 14, lordship.
All right, you
Oh,
come
sorry.
prepared after vacation, we'll close it then. This
Okay,
is not the way.
Actually, there's
Uh,
a direction of this court that if advised by the petitioner, then the restoration may be filed. In the meantime, lordship, they have not advised us to.
It's what restoration of,
Yes, lordship, your annexer 3, page 17,
it
lordship.
cannot be done. Contempt case once closed cannot be
There's
restored.
a liberty, lordship, liberty is granted to the petitioner to revive the contempt petition if so
You
advised.
file a review petition then. You are seeking advice from the judge. You have to share your fees then. On the request of Ms. B. Talukdar and counsel for the applicant, this matter is directed to be listed again after reopening of winter vacation so as to enable her to examine the legal issues and address the court.
Obliged,
Lordship 38, your lordship appears after vacation. Only my name may be shown, lordship. None appears. Your lordship is reflected. None appears.
And why should we adjourn it if you are appearing?
Otherwise, I am
Mr. B. Chakravarti, learned counsel for the review petitioner, has prayed for posting this matter again after winter vacation. Then so and so, so and so. On the prayer of Mr. Chakravarti, same date. All right. All over.